Your Excellency, Foreign Minister Timmermans, thank you for your leadership and thank you for your commitment to have signed together with me this joint statement of the promotion of peaceful settlement of disputes. Excellencies, ladies and gentlemen, honorable ministers, I'm honored to be here on such a momentous occasion. The centennial of the Peace Palace is a great cause for celebration. It is also time to intensify our work for justice and peace. I am deeply grateful to the government of the Netherlands for continuing The Hague's proud tradition of advancing these goals. They lie at the heart of the mission of the United Nations. Every day, sometimes every hour, I receive reports on conflicts raging in our world: Syria, Afghanistan, Somalia, Democratic Republic of Congo. These places show how the effects of conflict can last for generations. Today, the goal of settling disputes peacefully is as important as when the doors to this building was opened in 1913. The Charter of the United Nations requires all member states to settle their international disputes by peaceful means. And it offers clear directions on how to achieve this. Article 33 sets out a number of methods, including judicial settlement, arbitration, and mediation. I'm pleased that you will discuss these three topics and separate panels today. I'm also honored to see the presence of President of ICJ, Judge Tomka, and many other judges of international tribunals and international courts. The Charter gave the world the International Court of Justice. Member states may bring virtually any international dispute to the ICJ. Its judges have brought clarity and wisdom to a great array of issues: maritime disputes, environmental damage, international humanitarian and human rights law, and the application of many conventions and treaties. The court's caseload has grown in recent years, reflecting member states' increasing confidence in its value, and its cases have become more complex. The value of the court's judgment goes beyond the states that are directly affected. Collectively, these judgments have made an enormous contribution to the development of international legal jurisprudence. I commend all those states that have taken the high road of justice and settled their disputes peacefully at the ICJ. When countries widen the jurisdiction of the court, they enhance international stability. I call on all states that have not yet accepted the ICJ's jurisdiction to do so as soon as possible. This will fortify the international legal order. The drafters of the Charter and ICJ statute also provided for the court to express its opinion on relevant international legal principles and rules. The court has used this opportunity to address a range of public law issues at the request of the General Assembly, the Security Council, and other UN entities. My outgoing legal counsel, Ms. Patricia O'Brien, will discuss the important role of judicial settlement in greater depth this afternoon. Although she will leave her UN position soon, I'm confident that she will continue to promote the value of the United Nations in all of her activities. Arbitration, another invaluable tool, is one of the oldest legal methods for resolving disputes. The Permanent Court of Arbitration has a long and illustrious history. It has issued awards spanning a wide range of topics, from land and maritime boundary disputes to the interpretation of international conventions. I commend the member states that have used arbitration to de-escalate tensions and find non-violent ways to resolve their disputes. I'm especially pleased that this afternoon's final panel will consider mediation. The United Nations has done a tremendous amount in recent years to increase its capacity in this area. Our standby team of mediation experts have in-depth understanding of a broad spectrum of conflict management issues. When a crisis erupts, they can deploy within 72 hours any place around the world. I have placed a special emphasis on realizing the potential of women to mediate. That is why I have appointed a number of female mediators, and I have called for bringing more women into key positions in peace processes. I hope to see more women on all sides of the negotiating table, both as UN mediators and among the parties to talk. When women have been targeted, we work especially hard to empower them through mediation. This transforms victims into agents of progress. My special envoy for the Great Lake, Mary Robinson, is just one of many UN officials putting gender issues at the top of the agenda and working to solve problems in partnership with the affected women themselves. Excellencies, ladies and gentlemen, all different methods of settling disputes peacefully requires states to reject the threat or use of force. When they do, the rule of law can flourish. And when the rule of law prevails, societies and communities, nationally and internationally, can also progress and prosper. Despite the immense value of the tools outlined in Chapter 6 of the United Nations Charter, they remain underutilized. Our challenge is to show what they can do. When we make the most of these tools, we will reduce unnecessary bloodshed and build a more peaceful world. I applaud the judges, lawyers, and scholars who have worked in this building over the past century. They have made a meaningful difference in reducing conflicts, resolving disputes peacefully, and advancing international law. Ladies and gentlemen, I am confident that all those who will work here for centuries to come will build on their legacy, making this Peace Palace a truly global castle of international law. And I thank you very much for your attention.